Agnes Naroka is my colleague. Dr. Celestine Young and Sani is my colleague. Judge Martha Kameo is my classmate at the university. So I'm a friend and many other people that I know. So it's my pleasure to be here. I'll try to do my best to present in 15 minutes. I'll do my very best. So the topic for today is on gender and succession in Kenya, constraints and possibilities for women's care in a plural legal context. So what basically I aim to do, I hope that I succeed, is to examine how the competing gender and cultural norms mediate entitlements to inheritance in Kenya in a legal pluralist context. Basically, I'm asking myself, in Kenya, because we have a plural legal system, we have many different systems of law operating at the same time, and these systems interact in different ways. What is their effect on women's entitlements under the law of inheritance or under the law of succession? And specifically, how, when people invoke these norms, when they draw on different norms, and we shall see the different kinds, whether at the constitutional level, whether customary law, whether the law in the written law in the statutes, how does that affect women's access and entitlement to property? And because we are talking about care in this workshop, I'm also trying to see then what are the impacts of this framework on women's care. And what I hope to do is not just to identify the constraints, the difficulties or hindrances that women experience, but also what possibilities exist for women's care within this context. I use, in terms of analytical framework, the frame of legal pluralism, which I'll explain very briefly without taking a lot of time, and also the grounded approach to law, which are ways of thinking about law, which I find useful in this inquiry. But first, just to talk about, and I'm sure this is something that has already been discussed, the importance of property, especially land, for women's care, because land is a source of basic needs, a source of food. We produce food from our land. It is in land that we build our houses. That's where we get our income and a sense of security. More so in African communities, because of many of them, including Kenya, are agrarian. They are based on agriculture of different kinds. And therefore, where there is lack of access to that main resource, land and other forms of property, this makes women economically dependent, and it impedes their efforts at achieving economic independence for themselves and also for their families. So in this context, the law of inheritance or succession becomes important because it is one way by which women can have access to economic resources such as land and other property. So that is why then I thought of approaching this from the standpoint of succession. And you notice I'm talking about women. This is not to say, of course, that even men are not affected, but I think women face specific types of problems as far as the law of succession is concerned. So you will see that I focus quite a bit on women, but not to deny that even men might face difficulties. Something else to note is the relevance of marriage, kinship, and other affine or relationships for women. That women primarily acquire access to property through relationships. Either you're a wife, you're a daughter, you're a mother, you're a grandmother perhaps for the elderly, but it is through, or you're a daughter, through these relationships, that is the entry point for women to have access to property and land. And there is a link between women's care work, the so-called productive and reproductive labor, and entitlement to resources. What one notices is that generally women will have no problem as long as, first of all, they are connected to a man somewhere in their lives, but also that they are seen to be doing some work within the household. Care work, whether it's productive or reproductive, even though it is fairly invisible and actually undervalued, but if a woman is seen to be working, then there may be less difficulty in recognizing access. But where a woman is deemed not to be working, either because she's not able to work, maybe by virtue of her age, or for whatever reason she's not able to work or she's not seen to be working, then that becomes difficult. But in terms of invisibility and undervaluation of women's work, I think we've seen also the narrative of housewife. Many women in rural areas, when you ask them, what do you do? What is your occupation? They say, oh, I'm just a housewife. Or some say, I don't work because I stay at home. So work at home, and you see, for African women, I have actually almost would challenge you to name any woman who is a housewife in the sense of she just stays in the house. If you go to the rural areas, what do you find? Women are out there working either in their homes or in the garden, or they're out there trading. But there is this narrative that you're a housewife, and so if you're a housewife, you're dependent, and if you're dependent, you're not contributing, therefore you're not entitled to have property. Legal pluralism, as I said, is one of the analytical frameworks. Is basically a situation where two or more legal systems or normative orders apply in the same social field. And these are normative orders that intersect. They are not parallel in that they operate side by side, but that they intersect in different ways. And there's a theoretical concept by Sally Forkmore of the semi-autonomous social field, meaning that in society there are various fields, whether at the family level, or at the community level, country level, and all of these are interacting. And that's a useful frame of analysis, but I will not go into it because of the time. But what we see about legal pluralism, where we have very many types of legal systems, it gives rise to uncertainties in terms of knowledge. We don't really know all the applicable legal frameworks. So people end up knowing one side and not the other. When we sat here at the end of the plenary in discussion, we were talking about different possibilities for enforcing care of the elderly. And we talked about, we can use criminal law, we can use this. And people were like, oh, I had no idea that criminal law actually offers a possibility. So we have uncertainties. But it also presents certain opportunities because of its negotiability, flexibility, and the possibility to actually do what is called forum shopping, where you can choose among the different systems which one will you engage. The grounded approach to law has also proved useful, and I think it was been developed quite a bit by, I think, the University of Warwick and others, where you start, instead of approaching law from the high level of written law or international law, you start from the ground and you ask yourself, what are the experiences that people face? What are women's difficulties? And then you see how can we apply law in order to address. So you start from the ground up, and therefore the context is very important. So for our purposes, in terms of the law of succession, family law, as you probably know, comes in the context of plurality. We have very many systems of family law in Kenya, from the statutory law, if it's a marriage, Christian marriage, Islamic, Hindu, etc. And we're governed by several types of laws, different layers. There's customary law, what is also called local law, because customary law can be a difficult concept. Statute or common law, there's Islamic law, there's a constitution, there are international and regional human rights frameworks. All of these have something to say about the law of succession, and all of them interact. I don't want to go into definition of customary law. I think we generally know what it is, but I also just want to mention that it's never very clear what we mean by customary law. There's contestation about what does it mean, what is its content, how is it applicable, and some theories have actually said that there's such a thing as invented customary law, that some things which we think have always been with us actually are fairly recent innovations, but we think that they have always been with us. And that colonialism did a lot to change the way in which custom is understood. The other important thing is that at some point in our history, there was an attempt to write down customary law, because one of the difficulties that was identified is that Since customary law is unwritten, therefore it's very hard for courts and other people to know what it is. Therefore, let us put it down in writing. And while that might have been a noble idea, it actually didn't work very well, because the effect of this was that the customary norms, the ways of the practices of the people, the ways they behave, were put down in writing. So that, and that was in Kenya, it was in the late 60s, 1968, 69, we have what are called restatements of customary law, which actually write down, if it is from my community, Kikuyu, this is what the tradition is, the customs in terms of marriage, in terms of succession. Women don't inherit, and it is written in black and white. The effect of that is that then it leads to hardening of custom. People, the way custom is understood becomes very rigid instead of being flexible and dynamic. So we have the state official versions of customary law as opposed to the living law that reflects the actual practices of the people. Now, so as I said, we have different layers of normative frameworks. One of them is customary law, and because we are dealing with succession, we'll just say a little bit about that. And first to say that African societies are generally governed on the basis of patriarchal structures, where the man is the head of the family, of the clan, of the tribe. So it is men's rule, so to speak, and that women's individual interests come under the interests of the group, and where male members dominate over women. The effect of that is that there's a general exclusion of women from inheritance, especially land, because property tends to pass through the male line in patrilineal societies, which are the majority, and I know that there are other communities like the matrilineal, where succession is through the female line. That is also not unproblematic, but in Kenya, basically, we deal with patrilineal structures. So what is the impact of this on women's care? I think for those who live in Kenya, we are aware of the difficulties that widows and other women, daughters, face when their loved ones die and they're chased away. And one of the construct that has been used is that they are outsiders. Now that your husband has died, you're no longer a member of this family. You're an outsider. And of course, outsiders have no entitlement. So the narrative of the outsider then becomes quite important, because it is used to exclude women. Of course, women then have to fend for themselves in different ways. In some communities, elderly widows are regarded as witches. I think you know some of those communities, and many times they are killed. And what we find is that the original intent of practices like widow inheritance or widow cleansing has been subverted. It has been abused so that it results in exploitation. And in the context of age, that's also quite an issue. But of course, not all customary practices were negative. Actually, widow inheritance was supposed to protect widows, and women did use rights over land, over crops, etc. But what has happened then is we reinterpret custom in the light of modern legal forms. We individualize tenure, land tenure, so then men become the heads of households and women are excluded. But something that I would like to mention is that now we have some changing customary practices, because custom is not fixed. It is flexible, it is dynamic. So there are cases of fathers who give away their property to daughters who have taken care of them. My daughter, you have been very good to me. Please take this one. Even though under custom, women don't inherit, but you have taken care of me. The concept of trustee in some communities where women are appointed muramati or trustees, that gives them also the power to distribute land. So that gives them a bit of entitlement. But I want to say something also about the Law of Succession Act, because I mentioned that we have not only customary law, but we also have statutory law. The Law of Succession Act, which is the main law dealing with succession, it was supposed to be the only law, but it has certain exemptions for Muslims and for certain geographical areas where customary law still takes place. But I just want to highlight some of the provisions that are favorable to gender equality. One of them is that women are given equal legal capacity as men to make wills. It's generally gender blind. It doesn't seem to favor one gender over the other. Generally speaking, male and female children have equal standing. And that's something that I think many people don't know, because the assumption is usually that women can't inherit by law, even by under written law. But they can, because the Law of Succession Act actually does have those provisions. Widows and children are included as dependents, so they can inherit, and they can be appointed as administrators of estate. But there are also provisions that negate gender equality. One of them is certain geographical areas have been exempted from the operation of the Act. That means, and these are areas where it is expected that the lifestyle is still traditional. But the inherent assumption is that traditional lifestyles are static, that we never move. The way we have always done things in the days of our forefathers, we will always do. So that, and then the difficult thing is also our courts, for some reason, still apply those provisions of Section 32 to areas which are not gazetted. It's like just an assumption that because it's agricultural land, we must apply. There are others like Section 3.5 that it allows marriages which should otherwise be unlawful to be, for women to be considered wives, which is a double-edged sword, because on the one hand it protects women who have come into the relationship later, but on the other hand works against the first wife, because suddenly there are these women who appear from the woodworks and you never knew them, and now they have a share in your husband's late husband. One other quite important provision is one that treats widows and widowers differently as far as inheriting their spouse's property. Women only have a life interest in their husband's estate, but it stops after remarriage. Once a woman remarries, it is expected now she will move to her new husband's area, whatever, she will inherit there. But the men, even if you get married again, it's okay, you still continue to enjoy your wife's property. The other aspect of the Law of Succession Act that works against women is that in polygamous marriages, the widow is considered as one unit in addition to her children. So the adage, women and children, there comes very true. So you're just one among your children. So there's actually no right to the widow to inherit as a spouse. There's also the assumption that all property in the family belongs to the man. So no recognition of the wife's contribution to the wealth of the family. A very, very important omission in the Law of Succession Act is that it doesn't give the widow the right to retain the matrimonial home. So it's like everything is up for grabs. When the man dies, now everybody is fighting who gets what. But there are jurisdictions like Ghana which very clearly say when a man dies, the widow is entitled to the matrimonial home. And I think that's a reform issue that perhaps ought to be taken up. So I'll just also mention, of course, you're aware of the Constitution and all the good provisions which can be used to aid the cause of women, and also the international and regional instruments like CEDAW, like the Women's Rights Protocol. Lastly, and I know I'm a little out of time, but I just want to say something about the judicial approaches to customary law. It seems there are two major approaches to this question of whether customary law applies to succession disputes, and they're divergent. I've named them. One applies the norm of difference, the gender norm of difference, which is a conservative approach. The other is they use the norm of equality, the rights-based approach. The issue is usually, are widows or daughters entitled to inherit the estate of their husbands or fathers, especially land? So the conservative approach starts from the S.M. Otieno case. A Luo man, or in this case, any African man, must be governed by the customary law of his land. There's no way in which you can escape from that. So it adopts the official versions of customary law found in the restatements, found in anthropological works like Facing Mount Kenya. They talk about how customary law is notorious. Everybody knows that women do not inherit. And so it has really operated to exclude women. And I've just named some of the cases, Wabi and Wabi, etc. Now, the critique here is that uncritical adherence to static versions of customary law has no regard to the present day practices. It then asks ourselves what really is happening on the ground. It disregards the flexibility and dynamism. It also assumes that all wealth belongs to the man. So of course it renders invisible women's contribution to wealth, it denies them entitlements, and it perpetuates women's poverty. The rights-based approach, on the other hand, starts from the standpoint that customary law does not apply. So they apply the act, and they also apply some of the international and regional frameworks. And this has led to actually good results as far as women's issues are concerned. It results in favorable outcomes. The only thing I would say is that perhaps judges also need to think that, and I'm glad I see my sisters who are judges in this room, that I think an unintended consequence of this approach is that it still tends to take the official static version of customary law, that customary law is oppressive to women, so we can't use it. We'll declare it repugnant to justice and morality, and then we use the human rights ideals, which is okay because it leads to good results. But I think there might be a lost opportunity there to infuse human rights ideals into customary norms and practices instead of wholesale condemnation. So I feel that perhaps overall the judiciary needs perhaps to reinterpret and reconceptualize customary law in line with present day realities, and then develop a progressive jurisprudence of customary law. My last slide, way forward. What are some thoughts in terms of how do we get out of this? First, I've already mentioned, to rethink customary law in a way that goes beyond that dichotomy where we say customary law is bad, human rights, statutory law is good. And then actually, I think it is my friend Celestine Nyamu Musembi who talks about critical pragmatism. That there needs to be a focus on what is the actual context and what are the consequences, so that women are able to use the opportunities that are presented by these plural normative orders. So you use what is good, you challenge what is bad, and that gives you agency, a sense of agency, rather than victimhood, so that you can actually make decisions. I think another way would be to engage constructively with traditional and community justice systems, because these are, for most women, the most viable dispute resolution forums. Article 159 gives us some basis for saying that, let's engage, so that these assumptions about what is customary and what is not can be challenged. Grounded research, this is an approach used by the Women and Law in Southern Africa and other women's bodies, where you actually do research, and this can feed into judicial education or re-education, so that as judges are making decisions, they know, okay, the practices have changed, they're like this. And I feel that legal literacy initiatives also, so that women are more aware of their rights. Thank you very much.
Thank you, Professor Kamau. So now I will invite our next panelist, Dr. Pacifica Okemwa from Kenyatta University.
Thank you. Hi, everyone. Speaking after such a good read of mine, thanks so much, Professor, for that good presentation. So what I'm going to do is talk about, I'm not going to use a slide, I'm sorry. The reason for that is very simple. What methodology do I want to use in presenting my paper? The title is very simple. It is Women, Caregiving and Recognition, a Case of Domestic Workers in Kenya. Now, like you were told, my name is Pacifica Okemwa, and let me start by a little story, just to be able to contextualize what I'm talking about. I have been involved in more than 5 researches on domestic work. My initial interest was a case that happened to a neighbor where I lived, and the domestic worker in this neighbor's house was sexually violated by at least 5 people in the same house. there was a case of a watchman, a gardener, a relative, a son, and I think some visitor who came visiting one of the sons. They all had sex with that particular child. And so the neighbor was so infuriated, and she comes to a women's meeting and says, you know what? I'm going to sack that girl. I'm going to show her where she belongs. So the question was, have you solved the problem? By sacking her. And so the conversation around what is it that domestic workers face in some of the households in which they work. How do they get to solve some of these issues? What sort of care are they even receiving at all? Then I ended up writing a small paper. I was a student then, so I ended up writing a small paper at that particular time, and I had it published, and that attracted someone else. And the someone else invited me to bid for a job, and so I got a job as a consultant to be a lead researcher and collect data on domestic workers in Kenya. And so in 2015, I am this lead researcher. I design tools, and we want to find what is the situation of domestic workers in Kenya. And so we end up publishing these as a paper which exists online. It was by an organization called IDEA Kenya. And so we found out a lot of things about domestic workers. And then in 2016, another organization again hired me to look at casual domestic workers and to collect data in 5 informal settlements. Again, I ended up collecting data on domestic work. And so what is it that is interesting for me out of all these researches? Granted, we were able to collect data, we were able to write and all that, but one thing kept on ringing in my mind. Who cares for the needs that domestic workers have? What are these needs anyway? Earlier in the day, we were told that we don't pay our domestic workers enough. But for me, the bigger question is those needs behind the economics, the economic gains from domestic work. Who takes care of them, among others? And so in this particular presentation, I'm going to talk about women and caring from the point of view of the caregiver. Who is it that cares for her needs? And how are they met anyway, all these needs? I'm going to use a storytelling approach, and that's part of the reason why I really do not want to use PowerPoint. African societies tell stories all the time. And when we tell stories, we need a key to be able to interpret these particular stories. And therefore, for this particular paper, I use a 4-step approach to interpreting these particular stories. First and foremost, step number 1 is being able to listen to the story. So in the case of domestic workers, do we have time to listen to their stories? How do they relate those experiences that they go through, whatever those experiences are? So if we teach ourselves to listen to the lived experiences and then to be able to seek to understand those experiences from the point of view of the caregivers themselves, then we might get something. Step number 2 is having to do a critical analysis of those experiences. Now, using legal frameworks, using provisions that may be existing in terms of what is it that are the rights of this person versus what is it that they are able to implement on their own and all that. So critically analyzing all these stories based on frameworks that exist, whatever those frameworks might be. And thirdly, being able to decipher all these stories and picking out issues. If there are issues of oppression, can we pick them out from those particular stories? And once we pick them out, what questions then do we raise on this? And lastly, searching for clues to transformation for me is very, very important, because we've listened to the stories, we've been critiquing them, we've even pointed out where the issues are, but we need like a transformational angle to all this. And therefore, looking at what are the care issues of women domestic workers, I noted the following out of all these researches I have done on domestic work. Number one, like any human being, they have social, economic, physical care needs. And how do these emanate? Some of them even emanate from the kind of work they do. There were cases where girls and women told us, you know what, I was involved in an accident while I was working for my employer. You see, there was a fire that broke out of a small mistake with the kerosene stove, and I got burnt. And so I would ask, then what did you do? Oh, my employer took me to hospital, and I stayed in hospital for a very long time. And when I was discharged, she removed me from the hospital and told me because I cannot work anymore, I would have to be taken to my raw home. So I have been at home recovering. So the next question ideally would be, while you were at home, who took care of you? You know, and was this care sufficient? And they would tell you something like, my mother did this, my auntie helped at some point, but it was very difficult because of financial financial needs I had, the healthcare needs I had, and all that. So you realize that when physical challenges arise out of the accident, it's very difficult for domestic workers to be properly taken care of in our scenario. The second concern over and above the accidents was the whole issue of the violences that domestic workers face. It's important to understand that by virtue of their social status, domestic workers, like all women of course, are sometimes regarded as second-grade citizens, but being domestic workers kind of makes it worse for them. So if women are oppressed, then domestic workers are doubly or triply oppressed by virtue of their social position. And therefore, because of that, it was important again to begin to ask questions around the types of abuses that they face and how they are able to resolve some of the abuses. And we can cluster all these abuses around maybe 4 or 5 areas. Some are sexual, like what I explained earlier on. Some are economic, others are social. So people are denied even small things like association. You know, you can't visit your friends, you can't make a call anytime, you know, that you want, and all that. And therefore, and so the question was, when you're faced with something as serious as a sexual abuse, what do you do? The common response was what to do. I mean, I just had to put up with it. It was so shocking, but I had to put up with it. Because what choice did I have as a domestic worker? If I got out, then I lose this job, and you know I have children whom I left at home with my mother, and we need this salary, and I don't have a place to go. Do I get out at night? And so there's a lot of, putting up with all sorts of abuse, be they physical, be they psychological, be they sexual, and all that, which is very, very problematic for me. And lastly, who do you talk to when you have psychological problems? Again, there were issues around, I really do not have anybody to share with. But having said that, I want to also say that there were stories that were very, very different, where domestic workers said, you know what, my employer is one of the best, over and above ensuring that they pay me on time, and that this employer is also a friend, and therefore I have every need I have, I sit and talk to my employer. So when my children did not go to school because of lack of fees, I talked to my employer, and what she did is she gave me a salary advance. So I was able to take my children to school. And I'm very happy I can do everything within my powers to be able to fulfill my duty to this particular individual. And so, at the end of all these cases and stories that I have been listening to, one of the things that I came up with as a conclusion is, questioning the kind of research and documentation we do around domestic work. Sometimes we are so quantitative in our collection of data to an extent that we miss out some finer details. So we ask questions like, how much do you earn? So 3,000. Oh, 3,000 is very low. But we don't go into the detail of when that person was paid 3,000, what was the context of the 3,000? What else was the basis of the 3,000? And how would that be, interpreted differently? Like the lady who was paying school fees for someone's children, paying her salary, but also giving her a salary advance for her to be able to sort out those children. And the second thing, I think I need to say this over and over again, something I recommended in all the researches that I have done, is that we need to rethink education for domestic workers. While in Kenya, for example, we do trade test training, industrial training for drivers, not drivers, what are these people? Mechanics. We do trade training for artisans of all kinds. We don't have any package like that for domestic workers. And therefore, it becomes very, very difficult to be able to peg a salary for a domestic worker because we assume they don't have education. And therefore, my recommendation, and this would be what would be the transforming clue for all these stories, is can we begin to think about functional skills education and package this kind of education in modules that could easily be taken by a domestic worker and then tested within the trade testing centers that already exist. So that the modules could be things like childcare. So I learn childcare as a domestic worker, and I can easily learn this childcare even within the context of my work. I'm already working as a domestic worker, but the module comes in a simple to read, very visual kind of booklet. So I can go through it. I can even go through it with my employer. Once I finish this module, regardless of what time, what period it takes, I'm ready for the trade test. I go register and I'm able to take the test. So I finish module 1 and I can now go to the employers and say, you know what? I'm qualified in child care. My salary needs to go up because I'm now qualified. I have a certification for child care. Then I take the next module, maybe cookery, maybe appliances. Fantastic. How do I use these domestic appliances? Microwaves, iron boxes, gas cookers, name it. How do I use them? And so, again, I take all these, I study them together with my employer, who also has interests, by the way, because this employer is being served and they benefit directly from the knowledge of the domestic worker. So what am I achieving with that kind of training? And the modules can go on and on to cover all the needs. What am I trying to drive to? That education of the domestic worker would be packaged in such a way that even the employer is aware that this individual is taking a course, and that they begin a conversation around how are you helping this domestic worker. Because where we work, by the way, our employers are keen to see us gain skills so that we can improve our services. Why would it be so difficult for us to think about improving the skills of our domestic workers just so that they can be able to serve us better? The argument that would come is that if I teach her, she will go away. Excuse me, if you don't teach her, then you stay with a mediocre kind of domestic worker who will one day burn your house or kill your child out of some domestic accidents. Thank you so much.
Thank you.
Right, Ambrina's with us. She's been listening.
Hi, Ambrina.
She's now going to move on to another system.
Right.
So Professor Ambrina Manji is joining us via Skype shortly. I can see her on the screen. I think the panelists can too, and she's been following. So she's going to be with us shortly.
Whilst that's happening, can I just say that in your pack, there are two bits of paper. One is the program and the outlines of the papers and the biographical. In the back, behind it, you've got another set of pieces of paper to task you. But what this tries to do is I provided a little bit more background detail with some of the issues, like, what does the social development goal actually say? What are some of the key definitions about care? And sometimes you hear this word social reproduction. Academics talk about social reproduction. This is a highfalutin way of saying this is the work that is done that doesn't get recognised in the economy as productive that we've been talking about. But also it gives you a little bit more detail on some of the points that we're making throughout the workshop. So, for instance, in the programme, and I'm confusing you completely here, one of the questions is, does the Uruguay provide an example? Well, like you're at school, the answer to what does Uruguay do is actually on page 5 of the background notes. So you can crib the answer to whether Uruguay, because Uruguay has passed an act which is called a CARE Act. So if you want to learn a little bit more, give a bit more information, then you might like to refer to those notes in the back on the other piece of paper. So just whilst we're getting Ambrina up, then I was saying that.
And the other thing is, some of you may not have packs, so if for any reason you don't, please come see me, and we will try to arrange to have some printed. So I'll be sitting at the back, so after this session, come find me. And please, tomorrow, bring your pack, bring your notebook, so that we can, because we don't have so many copies. Okay, I'm going to call Ambrina now. We're going to
You up here,
Hello?
Ambrina.
Hello, everybody.
Great. And this doesn't really give you much of a view, I have to say, but is that all right?
I can hear you quite well. Can you hear me?
Very well.
Very well, yes.
Here?
Good.
Great.
Excellent.
There you go. And yeah, feel free. Go for gold.
That's great. Thank you, Jenny. Thank you very much for inviting me to join you. Particular thanks to Anne Stewart. I'm sorry I can't be there in person, but what I would like to try and do today is speak about what I think would be an interesting perspective on the themes that you've been discussing today, care labour and its performance, and particularly its recognition. And I want to try and do that from a historical perspective. So my argument is that in recent years there's emerged a growing literature on care, on its meaning, on its content, on its quantification, and also on the possibilities for its legal recognition. But the existing literature has tended to focus on contemporary manifestations of care work. And I was curious to explore whether using historical material as a source might give us interesting and important insights. So I'm interested in the idea of going back to look for care and thinking about what doing that might do to our thinking about caregiving and care receipt. So I wanted to ask, how do historical accounts of women's reproductive labour, for example, what do those historical accounts tell us when we look at them again, when we read them again anew through a care lens? So in the paper I want to talk about today, I revisit Janet Bujra and Louise White's path-breaking work on prostitution in colonial Nairobi, and I look at that work again to see what I can pull out of it that relates to care. The authors don't use that word, but I want to see if I can reread the texts to find accounts of care and its treatment. So I focus in this paper on two themes. The first is that I look at the labour forms of prostitution in colonial Nairobi, which Louise White uncovers in her book. And I consider them, these labour forms of prostitution, I consider them as forms of care labour. And I focus on what Hochschild has called the creation of an urban, intimate labour class. The work these women were doing was intimate labour. They were coming together as an intimate labour class. So that's the first thing I want to do, is consider labour forms. The second thing I want to do is I want to look at the strategies of property accumulation of some of these women in colonial Nairobi. So Bujra and White studied colonial prostitution, and what they both argue is that the strategy of particularly Malaya women, and I'll come on to the different forms in a minute, the strategy of Malaya women in colonial Nairobi was related to property accumulation. That was what they were interested in doing. And in this paper I talk about what I call a care property nexus. I think something interesting was going on in relation to providing care and accumulating and inheriting property, and I'll say more about that in a minute. So the argument made by White is that the work of Malaya women reproduced male labour cheaply. And these Malaya women in prostitution were able to engage in rapid, independent property accumulation. Independent in the sense of it didn't entail any relationships with men, it entailed becoming independent property owners in their own right. And that these women were determined precisely to deny patrilineal kin, and they were determined to disinherit fathers and brothers and uncles. And these women created what Bujra calls pseudo-kin. So they adopted independent kin of their own through, for example, women-to-women marriages. Now, Bujra doesn't say this, neither does Louise White, but in this paper what I argue is that actually what was going on here was very much to do with care. So I ask, well, if it is to do with care, what else is it to do with? If it's to do with property, for example, how is that property transmitted? How do women, taken in the form of marriage that we're calling women-to-women marriages, how do they receive their property? How do they frame their claims to inheritance, if at all they do? So what I'm trying to do, just in summary, is to understand care labour and property and how they're related, but to do that in historical perspective, to use historical material as a source, and to go back to look for care, in order to then think about what does that tell us about giving care and compensating care in the present day. Right, so what I try and do is to think about the strategies of property accumulation of women in colonial Nairobi. Okay, and what I argue is that because of the way that they practiced their prostitution, and I'll come on to the details of that in a minute, they accumulated significant amounts of property. That property we could call bequeathable assets. Berman refers to property in this way as bequeathable. It can be then handed on, for example, in your will. And this, I think, is very interesting because it allows us to see the connection between care and property. It allows us to explore the nexus between care and property, both upstream and downstream. So upstream, I would say, the work of Malaya women reproduced male labour cheaply for the colonial state. Malaya women, largely in the context in which they were operating, they supplied cheap labour, or they subsidised male labour for the colonial state through their work, but in their subdued, respectful form of prostitution, effectively they acted like wives. But at the same time, their practice of Malaya prostitution enabled women to engage in rapid, independent property accumulation and to disinherit male kin. And they then took on new kin, young women, pseudo-kin, Bujra calls them, who in turn provided care for these Malaya women in their old age. That's the kind of upstream link that I'm interested in. Downstream, you could say the choice to take on new women kin, to disinherit your male relatives and to take on new women kin, constituted for these women a kind of what I call a bequest strategy, based on care considerations. So this is the downstream idea. What women were doing was, they were, I think, Malaya women, bequeathing their accumulated property in return for care received. Now, what I'm interested in is how do these strategies of accumulation and of bequesting work? Or let's put it another way. In what ways were the strategies of care giving and of bequest intertwined? White argues in her research that in colonial Nairobi, the work of prostitution, the work of prostitutes, particularly of Malaya prostitutes, was family labour. Prostitutes reinvented or recreated patterns of family life. And she pays particular attention to labour forms in colonial Nairobi. In fact, she tries to reconceptualize prostitution in colonial Nairobi through its labour forms. So she says, between the 1920s and late 1950s, colonial prostitution in Nairobi was connected with strategies of reproduction, not with strategies of personality. So she sees these women as highly strategic. And she says each form of prostitution that she identifies had its own characteristic. And that characteristic of the form of prostitution determined its rate of accumulation, but also the way in which labour time was organised in that form of prostitution. And she distinguishes in her work between Watembezi, Waziwazi, and Malaya prostitution. Okay, in the Watembezi form, you'll understand, kutembea from Kiswahili, women simply walked the streets and solicited on the streets. In the Waziwazi form, they sat outside their doors, they called to men, they engaged in brief sexual encounters in which they provided sexual services, but very rarely any other service. The Malaya form, most interestingly, was a stable form of prostitution, offered by women. Often these women had been converts to Islam, from their rooms and later from their houses. These women were not out on the street. These women were very demure, outwardly respectful. These women had begun life as urban tenants. They'd come to Nairobi and rented properties, but they practiced a form of steady and slow accumulation of property in their own names. Over time, they accumulated for themselves or established for themselves the status of heads of households. And Louise White says these women had a healthy respect for the value of real estate. So Waziwazi women, for example, originated, they say, in Bukoba, in the northwest of Tanganyika. They came to Nairobi to accumulate money. They sent that money back to their fathers in order to help the fathers and families cope with the recent integration of the region into the world economy. So the region northwest had been compelled to grow cash crops such as coffee. They were finding the integration into the market difficult given the instability of prices for coffee, and these women were simply almost sent to Nairobi to earn money to act as a buffer between the colonial state, or coffee prices, and families. So these women, Wazi women, are really their form was the prostitution of daughters. They stayed connected with their male kin. They assisted their male kin. These women, Louise White says, saved a generation of indebted cash crop producers. They saved them. When they came to Nairobi from Tanganyika in the 1940s, they took their earnings from Nairobi and handed them straight back to their male kin. And what White shows brilliantly in her work is that this labour form, these street-walking, aggressive prostitutes who were widely condemned all over Nairobi for their shameful public behaviour. They would call to men in the street, they would aggressively follow men, they would dress provocatively, etc. They were widely condemned at the time. But actually it was those women, Waziwazi women, who were the most loyal to their male kin, who were the most familial, who really had ambitions only on behalf of their families, not themselves. All of their earnings went back to their brothers and fathers in order to stabilize their male kin, to establish them as smallholding farmers or as shopkeepers, for example. In contrast, Louise White says, Malaya women who practice this slow, quiet, almost invisible, Islam-inflected form of prostitution, in which the values were values of honor and concealment and demure behavior, these actually, ironically, were the women who were really in it for themselves. Their outward, demure behavior, propriety, actually masked the reality that they fully intended, immediately as they were able, as soon as they were able, they intended fully to disinherit their male kin. And I love the way that Louise White picked up on that deep irony. In doing this, Louise White says, Malaya women were inaugurating a cycle of family and lineage formation in literal and concrete terms. They were actually creating their own lineage. They were involved, she says, in class formation. Malaya women, she says, were joining the ranks of the urban petty bourgeoisie. In the space of 25, 30 years, they formed a class of their own. They valued property, they bought property, they dealt in property. Now, it seems to me that account of domesticity in prostitution in colonial Nairobi is really rich and suggestive for us if we're interested in care labour. In Kenya, the colonial state recognized that Malaya women were playing an important role in reproducing male labor for them. The state was structured, the Kenyan state was structured at the time, the colonial state was structured around a migrant labor economy, and the colonial authorities knew that these women could reproduce male labor cheaply for them. These women provided sexual and reproductive labor. They provided homes for these men to stay at occasionally. So this Malaya form of prostitution effectively enabled the colonial state to depress wages, because migrant men didn't have their own families into the urban areas, into Nairobi from the rural areas, and they didn't therefore have to be paid a family wage. They relied for reproductive work on this set of women in Malaya prostitution. So Malaya women formed a feminized, urban, intimate labor class, Hochschild calls them, who through their work subsidized the colonial state. And so what Louise White does is she says, well, what sorts of services did they produce? Did they provide? What sort of sexual services, but also what sorts of, she didn't use this phrase, what sorts of care labor did they do? Now, I wrote to Louise White when I was writing this paper and said to her, I've reread your work. I'm very interested in the accounts that you give, and I think that we could call a lot of what you're describing care labor. And she wrote back almost immediately and said, I'm really interested to hear this. I didn't ask the questions in that way. I wasn't thinking in those terms. I didn't have that lens. This kind of language that we're using nowadays wasn't around. But yes, you're absolutely right, and I'm kicking myself that I didn't ask, I didn't see so specifically how care was implicated here. And she says, my case studies show how instrumental women were about care, and I'll come on to that in a minute. So it was very reassuring for me, because I reread Louise White, and then corresponding with her and having a confirmation from her that I'm not wrong was really important and reassuring, that I'm not misrepresenting or misreading what I think happened in her research, or what was coming out of her research. So Louise White said, Malaya women provided the amenities that working men needed. So they would say to Louise White, what we did was we talked to men. We gave them tea. You keep your house clean. No one could tell this man wasn't my husband just by looking at us. Okay? So White says poor men could purchase fleeting domesticity. They could have the odd relationship, maybe have a meal cooked for them. But more skilled and self-employed men could afford night-long imitations of married life, she calls them. They could have bath water, they could have bread, they could have respect, they could have cleanliness. They fell in, men and women, to this gendered vision of service which men could purchase. So Malaya women as women were not just being paid for the task-based labor that they were performing. They weren't just being paid for sexual services or even for meal. They were being paid for emotional commitment and intimacy. So men wanted loyalty, they told Louise White. They wanted loyalty, they wanted personal attention. They wanted, and this is interesting, they wanted to be greeted in their own language. They wanted the reproduction of intimacy. Now, of course, that was a difficult thing for the colonial state to handle. It's one of the contradictions of the colonial state. The colonial state needed these women to assist in the reproduction of labor, but it was clearly going to be ambivalent about their work, because the result of these women's work was the accumulation of property, and it was class formation. And that was a difficult position for the colonial state to be in. And I'll come on now to talk a little bit about property accumulation and what I call the care property nexus. I want to think a little bit about what is the connection, the relationship between care and property.
Andrea, 5 minutes.
Thanks, I can. Give me a few minutes, that's great. What I think is happening is that in the Malaya form, we see care being recognized and compensated through the mechanism of the bequest and in the moment of inheritance. And to do this part of the paper, what I do is I draw on excellent work by somebody called Faustine Kalabamu, who writes about peri-urban Gaborone. And if you don't know his work, you should look it up, Kalabamu. And he focuses on new practices of inheritance by daughters in peri-urban Gaborone, in spite of discriminatory customary rules that actually disbar girls or women from inheriting property from their parents. And what Kalabamu says is, actually there's an increase in parents choosing to endow their daughters with property after their death in recognition of care investments made by the daughter. So, you look after me when I'm old, and in return, I will leave you in my will this land or this house. Okay, and he refers to it, Kalabamu refers to this as a duty beneficiary principle which is emerging. and that, you know, this caregiving is not uncontested by male kin, but there's a kind of agreement between daughters and fathers and elderly parents. You look after me and I will leave you something in my will, the duty beneficiary principle. And a number of authors, and I won't go through this in detail now, talk about bequests in this way, and they say bequests often for services rendered by beneficiaries. There's nothing altruistic or ad hoc about this. In fact, it's very strategic use of property. You reward a child for care, which they provided in their old age to you, and you provide it post-mortem in a will rather than inter vivos as a gift. And what I think was happening to go back to Louise White in the colonial context, was precisely this. That women decided, Malaya women having accumulated property, decided not to pass that property back through the male system. They decided to disinherit their fathers and brothers, and they decided to keep their money and their bodies for themselves. So they used their property, accumulated through prostitution, to purchase or at least to secure care. Having provided care for men in the colonial city and taken these men's wages as earnings, women converted care labor into capital. They bought houses, they became landlords, they literally generated value with their bodies. But they decided not to pass this back down patrilineal lines. They were not working for their families the way that Wazi women were. But what's interesting is what happened to that property next. I think that there's evidence that property-owning Malaya women designated their own heirs. They decided to bypass or disinherit their male kin, and they bought on the market that which Asian women couldn't have otherwise commanded in a patriarchal context. They paid for care by promising it as a bequest to a younger woman. So Louise White was told, this is what you would do. You would bring a woman to the chief, and you would say, another woman would say, this young woman is my wife. They transmitted property to that woman. They brought her, for example, from the rural areas. They befriended her. She cared for them. And they would say to the chief, this is my wife. And it's interesting to note that Louise White found no evidence when she was studying the Malaya form of prostitution that any property accumulated by these women was ever transmitted to a man. So she says, this was literal class formation, the creation of bonds of place and property between two women who were seemingly kinless. They had no relation with each other. They were kinless. They were kinless backwards. In other words, they had no male kin anymore. They cut themselves off. But they were also not blood related to each other. They were pseudo-kin, in Janet Bourgeois' phrase, with each other. So what I've tried to do in this paper then, just to summarize, is to reread Janet Bourgeois and Louise White, to read existing texts, existing accounts where questions about care were not asked, but to ask questions of care of these texts in the present day, and to treat these books as if you like, as a source, and to go back to them to look for care historically, to say what sorts of forms, what sort of labour forms were going on, do these implicate care, and how is property used to connect somehow with care. And I hope that by doing that we can cast some light on our present debates about caregiving and about care receipt and about care compensation today. And I'll leave it there.
Wow.
Thank you, Professor Mrina Manji, for that very insightful and interesting discussion. So we have now come to the end of this particular discussion.
If anybody might have any questions for Ambrina while she's online, that might be. Does anybody want to ask Ambrina anything or any discussion about Ambrina? Any questions? Because we've got her with us at the moment.
Yeah. Any questions?
Oh, quite a lot of questions.
Mine is a comment. Thank you so much. You know, we we look at prostitution. We have looked at prostitution, but not with the kind of eye that Ambrina has let us look at it. And I think for me is an eye-opener that we should not always look at things consider things or at surface level. There is much more to that meets the eye in all these things, and especially in that prostitution. If I was still a younger lawyer, I would go deeper into it. Thank you so much.
Thank you very much indeed.
Thank you, Prof. My name is Martha Kome. I'm a judge in the Court of Appeal. This is very, very interesting because even as we settled the disputes of woman-to-woman marriages, we could not trace where it came from. But now listening to you, I can situate two cases that the woman accumulated wealth in towns and in the city and had this woman wife, the younger woman working for her. So I have two cases that actually fit the study of Ruiz White. What I don't know whether Ruiz White has done is followed through what kind of arrangement this Mariah woman, that's a very derogatory, term here in Kenya. Yeah. Maybe we will find something else, some other description of this woman who was very empowered, that time. Because the problem is they will go to the chief. It's an informal arrangement. And the younger woman is very vulnerable because she's coming from a poor background. She has very little education. She is coming to be helped by this woman. So when this woman dies, the wealthy woman dies, then the family comes. And they come in arms to say, look, the woman says, look, I was married. This is my husband. They say, you are a worker. You are just providing care. So you leave because she has gone. The property is ours. We are the kinship. We are the brothers. We are the uncles. We are the ones entitled. And then the problem came because she says this is a customary practice of woman-to-woman marriage. So where are the customary rights that conform with the customary marriages? Because they must go through the steps of a customary marriage for it to be a valid marriage. So that was our dilemma, where I said, look, this woman had a legitimate expectation that she will inherit, and therefore I gave her property. I found problems. Then I was in the High Court. I found problems. The Court of Appeal setting aside my judgment that this marriage did not conform to the customary marriage. So I don't know whether Ruiz White followed it through to see whether these younger women were able actually to take possession of those properties. Thank you.
We don't know the answer to that, do we? Her research.
We don't.
Do we?
I suspect that in the colonial context, the fact that there was some distance between the properties and the families, geographical distance, probably helped. So if a woman had accumulated property in colonial Nairobi, but she was, for example, from Tanzania or from had left her male kin in rural Kenya, then it may be that she was so disconnected from her male kin that they were no longer in contact with her and so couldn't contest the decision. You're absolutely right. In the modern day, what you describe does happen, that there's a contestation by male kin. They're still in touch. They come in after the death and they say, you may see yourself as, you may describe yourself as the wife of this woman, but in fact you were nothing more than the domestic worker. You provided care under the framework of being their worker, their care assistant. You were never in any way their kin. That's absolutely right in the present day. I think in the past, Louise White's accounts seem to suggest the male kin were literally cut off geographically as well, and so the contestation just couldn't have been as great because they simply didn't know about the property and the extent of the relationships and so on. But I completely agree, and we see this in the courts, don't we, Anne, that there is now this emergence of contestation by male kin over the rights of a woman to inherit another woman's property.
Thank you. Any other questions to Ambrina? Oh my goodness, right, okay.
Okay, my name's Eva Magiri. I'm a researcher. I'm doing a research on care work and also a head of training of a labor college. Now, what has really opened my eye on this is on something that I've really been studying, a theory proposed for domestic workers and caregivers called the theory of the prisoner of love. The prisoner of love theory says that the domestic worker will always stay there, work, take care of you, bathe you, cook for you food, just because naturally some people are predisposed to care and emotionally loving. But one of the biggest critique of this is that no, behind the care worker, behind the theory of the prison of love is a calculated agenda by the caregiver. And those who criticize say it cannot work. This is the most wonderful thing I've come across today. Thank you.
Yeah, just a comment. Thank you. I would really be fascinated to look at this again through the lens of commercial sex workers today in our cities, but also migrant workers who go abroad and leave their children behind with other women and the kinds of things that go on there.
One more back.
So this is a very explosive presentation, and yeah. But I have two issues to raise now. Yeah, I have two issues to raise. Now, one of them being, I'm trying to marry your presentation with Professor Kamau's presentation, because Professor Kamau talked about, women who come up from the woods in Howard when a husband dies to claim property. And I'm thinking, if we were to consider these women as intimate laborers, as you say, would that entitle them to more property? So we shift from considering or asking the question of whether they were wives or not, and simply saying, look, this is my husband, he is dead, he had 10 intimate laborers. What can we pay them for this intimate labor? Now, can that be helpful, in taking the conversation forward? Now, my second question is, because in considering prostitution essentially as some form of labor and intimate labor, it puts prostitution in equal terms with other forms of labor. Now, does then the language of rights, that is, human rights, for instance, with regard to care, can it be helpful in protecting, the rights of prostitutes and say, look, these are not prostitutes, they are laborers. So in this context, they are care laborers. So as we talk about, like my friend here is from Kudea, as she talks about the rights of domestic workers, we're going to say now, look, these prostitutes are also intimate laborers. So we shift from considering them as prostitutes into, turning it around into an issue of, labor.
Do you want to answer that, Ambrina, or not? Or just
no, I could. I mean, with that second point, I completely agree. I think that's very useful. I mean, the term Malaya is seen, heard as derogatory, and there is something I think very useful in rereading Louise White to think about how the material context within which these women were operating, the effect of their labour on, for example, male wages, the way in which they subsidized and enabled the building of the colonial city and the development of the colonial economy, all of those things I think are really important to try and understand and connect with present day, for example, present day prostitution and its role in an economy.
Thank you very much, Ambrina. I seem to be taking over your rocks. I'm standing in front of the computer.
No problem. Thank you, Ambrina.
Thank you all very much.
Bye.
I'll switch you off, Ambrina.
Good to see you. All the best.
Okay, see you soon.
Bye.
Bye. I'm going to switch you off. I'm switching you off there. So, I mean, do we want to have some questions, or should we have some tea and then come back?
I think we can wind up if agreeable. You want to take tea, or do you want to wind up this session?
Do we want to continue for a bit?
Yeah, let's wind up the session because we had lunch pretty late, and then we can then have tea or coffee before we come in for the next two presentations, if that's okay. Okay, some questions for Professor Kamau and Dr. Okemwa. I think what we do, we take a round of say 5 at a time, then we can do 2 rounds. Okay? Any questions, or shall I let Professor Kamau respond to David? David, you have a question.
I think it's sorry.
My second question is also to you. So, I want to be a devil's advocate. Now, in my community, we have wife inheritance. And the difference between wife inheritance and essentially remarriage is that when you remarry, you move from your husband's home to the home of the person you are marrying. But for wife inheritance, you basically bring the man to that home. So originally it was that you would bring, a man who is related to your husband, but now it has metamorphosized a little bit, so you can bring essentially any man. But if I'm to look at it in terms of, because you talked about once the woman remarries, the woman loses entitlement to the land. Now, in my view, the reason why you are entitled to the land is because you've gained admission into the clan through your husband. And so once you leave this husband to go to another husband, you lose entitlement to this land. So I think that then wife inheritance provides you with an opportunity to get another husband and still be entitled to land. Don't you think? Because then wife inheritance would, when you are inherited, essentially you are still you still control your late husband's property. Yeah. So you bring the man, and the man lives there. He has no rights. He has no rights at all, the new man. So essentially, you still have control over land. So instead of, condemning wife inheritance, you actually be advocating for it as a mechanism of having women control land after the death of their husbands.
Thank you for both presentations. I am quite attracted by Professor Kamau's invitation to judges to include customary law in the development of the jurisprudence of human rights. And I'm very, very happy to do that, but I would like to know how, because the customary law that usually confront us is the negative one. Like, a woman, a daughter, is not supposed to inherit. So that is documented by Cotran. But these are negative, customary, practice that relegate the woman to the very that cause discrimination against the woman. How am I going to breathe human rights perspective to it and bring it out? There are certain positive customary practices that I would like to breathe life into, like caring for the elderly, the responsibility of the family to take care of their elderly parents and grandparents and all that. But I haven't come across a case brought to court, somebody filing a case against their children who have neglected, so that I can breathe more and more life into that aspect of the customary practice. Because as judiciary, we wait until people file cases. We have only had to deal with the negative customs and customary laws and wave them away and stab them in the back and say they have no place in this kind of situation. And for Professor Kemwa, I would like to, I've learned a lot myself because I've had I call her my house manager for like 10 years. And I would like to know how I can help, I can empower her to enhance her skill and get those certificates. Have you gotten to a level where they are being issued so that we can enroll them to get those certificates, or what can we do to help?
Anne has a question. All right. Somebody else before me?
Yes, mine was a follow-up to that last question, really. I was very interested in your idea of the training and the development of skills of domestic workers, because, and perhaps it's straying into what we might discuss later, but, where I come from, domestic workers have sort of, some have turned into what are called social care workers. So they're people who come to your home and help you look after your elderly, but they have skills. But they are, in a sense, broadening the perspective of someone that's providing care, which is a substitute. So when I wasn't looking after my mother, I had a social care worker who came to help me look after my mother. She was paid, but I think here in Kenya you would call her a domestic worker. And I just wonder whether, when you're saying skills in childcare, you might think about elder care as well, or whether you see could I dare to call it the market, developing those range of skills that might help people in their homes and support families who need a bit more help to look after elder people. But I wonder whether you see that developing, or whether there's a need, or whether that would be seen as stranger care and not acceptable.
Thank you very much. I have maybe two points to make. One is on property inheritance by wives or as of the life interest. The argument that you lose your life interest on remarriage, for me, does not make sense, although it is in the law, because even where you are moving to, you are not getting something permanent. It is the same road that you are walking. It is the same life interest. But what I would like to see is that as a woman, an equal partner in the family enterprise, I should be able to get the half that is mine. I can dispose of it if I wish, and to whoever I wish. But when I get a life interest, really, that doesn't secure me so much. So I'm hoping, Judge Koome, that when you are looking at the judgments on appeal, perhaps you'll bring in this new dimension. I don't know what the international conventions say about that, but I'm sure that there is something in that. And then the second point is on domestic workers. I think if we go back to the beginning of why people work as domestic workers here in Kenya, is generally speaking, we start from the premise that these are people who cannot who are unable to find anything better to do. If I'm not wrong, you will correct me if I'm wrong. So these are people who are not able to get something better to do. And even when it comes to considering them for training, perhaps most of us feel that they are not even capable of being trained. And yet, these are the people who actually nurture our children. When we are gone, they are the bosses. What the children learn during the 8 hours you are away is not yours. It is what these people are able to teach. And yet, we live with this as a necessary evil. If I could avoid it, I would have no domestic worker. And yet, because I have to go to work, someone has to remain to look after my children. Perhaps we need to have a paradigm shift in how we treat the domestic workers, because if we don't invest in them, then our children are not going to get, they will turn out to be the kind of people that our domestic workers are. And is that what we want? So I think we still have an issue there. Dr. Okemwa, maybe you look at it in more detail. That is my comment for now.
Thank you. So I think I would like the panelists to respond to those questions. But as you do, can I just just ask to Dr. Okemwa, as you were making your presentation, I was wondering, when we empower, and it's true we need to empower our domestic workers, but does that then mean that we remove their services from the reach of certain classes of workers that we have in Kenya? For instance, there are secretaries or teachers who will say, when we are told that we now have to make, is it NSSF and NHIF contributions and pay our domestic workers a certain amount, then you're saying to me that I will never be able to afford. Because we know that there are people who are in white collar kind of jobs who don't earn that 10,000, who do not earn that 15,000. But they have children, they have people who have to be cared for, and they therefore need domestic workers. Where do we draw the balance? Otherwise, we are going to face the real possibility that now only a certain class of people in this country will be able to afford domestic workers. And Professor Kamau, our legal system has been accused of two things. First, it is an adversarial system that is unkind or not very responsive to gender. Hence, going back to what Judge Kome was saying, that it's very hard to then begin to have a system, a legal system that can, look at customary law as living law and not necessarily as oppressive to women. But maybe if it was not adversarial, where you have your lawyer says what they have to say, my lawyer says what they have to say, and then that is what guides the court. So in terms of understanding our court system, is it capable of really understanding customary law in all its uniqueness? And secondly, it has also been accused of lazy lawyering as opposed to innovative lawyering, where lawyers just come with the same argument over and over again, yeah? Yes, and Judge Kome was saying it, are you a wife? Did you go through the steps of getting, are there other ways of arguing where we can actually secure the interests of this younger woman rather than having to demonstrate that she's a wife? Failing, if you do not do that, then you lose the case. Because it is actually lazy lawyering, seeing as our jurisprudence is actually guided by counsel. So there are those two things, and how do we bridge that gap?
Okay, thank you very much for those questions, some of which I really can't claim that I'll be able to answer really adequately. On the issue of the women, the Section 33, subsection 5 women, those who emerge, so to speak, from the woodworks, I think there's a real dilemma here, even among gender equality advocates, because there is a question of what is the position of that second or third woman. Presumably she had a relationship with the man, which was intimate relationship, akin to marriage. Probably there are children that have resulted. And the question is, so do you just wish her away and throw her out, or how do you deal with her? But then, of course, from the perspective of the first wife, this is an imposter. This wife is coming to take the share that I would otherwise have had. So I think it is a dilemma, and I think it just speaks to the complexity of our plural legal systems, where we recognize various types of marriage, customary marriages which are potentially polygamous. We have monogamous marriages. And the thing is, our gentlemen tend to cross the lines, you know. They maybe get married in church and then take up another woman, even though the Lord does not permit. So there are no easy answers. And actually the argument of the laborer has come into court. I'm sure the judges present can attest to that, where the subsequent woman comes, and then the argument by the first wife was, oh, this was a house help who worked with us, and then I don't know what happened, or this was some other woman who was working for us. And many of them actually start out as domestic laborers. So the narrative of intimate laborers is actually quite relevant. I don't know, what would I say? I think the court has to look at the situation, its situation on its own merits. And if on the ground there seems to be some approximation of marriage, we have the presumption of marriage that courts can, the doctrine that courts can adopt. But I think there has to be fairness, so that the first woman's due is given. In some jurisdictions, and some of them are African jurisdictions like Ghana, what they do is that if there is a polygamous marriage, the first wife takes the lion's share of the property, maybe like half. Then second one, maybe a division between the second and the third, and so on, so that at the end of the day, the first wife is not disenfranchised. But I'm just saying that is one way that some jurisdictions have dealt with it. So I think it's something we have to think about as a society. And probably the issue would be, because we have the Marriage Act, the new Marriage Act, which outlaws that kind of relationship. Why is it we still have those inconsistencies in our laws? Maybe a test case should be brought now, not just not based on claims, but in terms of jurisprudence. What do we do with Section 3.5? But I think these women can actually be called so-called intimate laborers. On the question of wife inheritance, I think we need to ask what was the original intention of this practice. It's there even in the Bible and in even other historical writings. I think the intention was to protect the woman and her family. But I think in modern days, it's actually an exploitative provision. First, because there is no choice. If the woman has no choice who to marry, can you really say that she is a beneficiary of this relationship? The other question is, who has control of the property? I don't think that in our context it is a woman who has control. So I would say that unless a woman herself has chosen to be inherited, we ought not to have this kind of, we should not condone these relationships. The question that, on the life interest, I think I agree with Justice Sitati. First of all, there is inequality, because why is it that the woman loses the life interest but the man does not? In fact, it should probably be the other way around, because men tend not to want to depend on women, but in this case, the man is actually benefiting from his wife's property. But I think for me, the question is, what place does a woman have in the acquisition of this property? The assumption is that this is a man's property, and therefore my husband has died and I just take a life interest. If I remarry, that's it. But most probably this woman had a role in, not even most probably, she definitely had a role in the acquisition. So I think we need to think of it in terms of share. What share do I have as a wife? And Justice Sitati suggests half, which is actually corresponds with the Matrimonial Properties Act, the principle. In some jurisdictions, they say the woman can get a third and marry, remarry, and move on, rather than just say she loses it. So I think the question is the share, that the woman needs to be seen as a contributor, direct contributor to the wealth. On Justice Kome's question about the negative customs and what can the courts do, I think one useful thing would be for the court to engage in research, grounded research. This has happened in some of the Southern African jurisdictions where women lawyers actually carry out research on inheritance patterns, on marriage patterns. And when a case comes to court, this evidence is presented to the court to show that the customs are not as they were 50 years ago. We have moved. And I think that would be a useful way of looking at it. The other question is on constructive engagement with traditional justice structures. I was reading an account the other day of a community where wife inheritance in the context of AIDS, HIV/AIDS was very prevalent. And of course, the narrative is that, well, you have to be inherited, you have no choice. But when, I think it was an NGO, a human rights NGO, engaged with the local elders, and they discussed and, they were convinced about the dangers. So finally they said, no, there should be women should not be forced to do this. So if we engage constructively with traditional justice structures, I think that's another way. I think in terms of what arguments can be advanced in court, I think if we think about us as Africans, we have the Ubuntu philosophy. Ubuntu, which talks about just dignity, about respect, about interconnectivity, about care. If we use some of those values, then even in a case where there is exploitation, then one can appeal to the court and say this goes against African values of care, for example, or of dignity, or etc., or a sense of belonging. So maybe we can invest a bit more on values. And lastly, and I hope I'm following on, the adversarial system in Kenya and the difficulties that we have with that. Again, I think the Constitution points to alternative dispute resolution, mediation. I think now there's court annexed mediation where parties can actually sit down. They don't have to engage in adversarial cases. And again, the role of research. I think maybe we just need to shift the orientation to a sociological approach to law, where we are actually looking at what is happening on the ground, as opposed to just looking at the laws up there. So, yeah, thank you.
Okay, thank you. I have quite a number of questions. I don't know whether I can respond to them adequately, but I'm going to try. Honorable Judge, I'm excited about your question because one of the things that I, have been doing is asking myself, what does empowerment mean to the domestic worker? And there are several answers to that. In your case, I would say this. First and foremost, have you had a discussion with the girl, the lady, with your manager, in regard to what are her hopes and dreams? And then can you build on those hopes and dreams just so that she can be able to realize that which she wants? I'll give you an example. Some time back, Yes, please. Some time back, I had a domestic worker who came and told me, you know what, I left my husband and I don't think I'm ever going to go back. And so the discussion was around, then what do you want to do? Do you want to stay in my house forever? She told me, no. I want to save all the money I can just so that I buy even a quarter an acre next to my mother. Then I put up a house and I will save some more and start a business. So I said, fantastic. Let us now begin financial literacy. How much do you save? How much do you spend on your needs? And in a span of 2 years, she was able to achieve her dream. And but before she left, she introduced another girl, and I'm like, okay, life continues. So it's important to get their hope, their dream, their view, because they always do. Everybody has that in their mind. And number 2, in regard to domestic workers training, there are very many versions. These people who develop curriculums had developed some sort of curriculum, but their idea of how it was to be implemented was not necessarily really going to be workable, because they thought that people would go to a mid-level college and then be trained to acquire those particular skills. But of course that doesn't work too well, because this domestic worker, who's going to pay fees for them, and how are they going to quit that job they're doing in order to acquire these skills? And therefore the suggestion that this sort of training has to be packaged in modules that can easily be taken by these particular individuals. Professor Ann Stewart asked about caring for the elderly. By the way, in this country, a lot of domestic workers are hired to care for our older, the elderly in our families. So if I went and picked my mother, she's incapacitated for one reason or another, I will even hire an extra domestic worker. Don't worry that I might not even equip her with skills or even, the kinds of materials she may need in order to be able to do that care. So for me, that's a gray area in terms of offering care. But again, in the nursing profession, there's something that is developing called nursing aid in this country. And therefore, you can easily go to Avenue Nursing Home or some other place where they train nurse aides and get an individual who is trained in caring for older persons or persons who are incapacitated in one way or another. And Justice Sitati brought an interesting question. Remember when I started my presentation, I said one of the problems with domestic workers is their social status and how they are regarded within society as a whole and our households. That narrative needs to change. It has to change. And who is going to change it? It's us as women beneficiaries. And I say this over and over again. I never want to say women are their worst enemies, because I don't think we are our worst enemies. Our worst enemy is a society that socializes us to think that we are enemies of each other, not necessarily as women. And therefore, as women who are direct beneficiaries of services of domestic workers, we need to be asking ourselves, what is it that we need to do differently? These are not necessarily people who cannot find anything to do or who cannot really do anything else with their lives. They happen to be disadvantaged in specific ways, but they are not incapable of training. And that's why we have to think practically in terms of skills as opposed to formal book education. Can we gain skills? Can this person learn? In any case, when you employ them, by the way, you teach them this is how to use an iron box, this is how to cook, and they learn. So what would stop them from learning this modular packed knowledge for them to get a certificate? And I'm simply saying the domestic worker doesn't have to do it secretly. She does it in conjunction with her employer, just so that she gains more knowledge in that particular manner. And so we need that paradigm shift. We need it like yesterday, and that we need to keep on pushing that area. And finally, there was the question of are we going to be able to afford domestic workers, considering, that they need to be paid a lot of money? If they get training, they are going to be paid more. My question has always been, which profession, and show me one, where everybody earns the same amount of money? So I started off as an untrained teacher after high school. How much did I earn? It was 800 bob. I'm sure you cannot even imagine that, but I earned 800 bob. And I went to university, worked as a secondary school teacher before, tutorial fellow, and name it. So what stops the domestic worker from progressing in a similar manner? From untrained to trained. And when we train them, it doesn't necessarily mean that they are going to leave, by the way. Because we are thinking in such a stagnated manner. It's as if we are fixed, and that even us who are employers, we are never going to change those domestic workers, or that we are never going to get a salary increment so that we can bless somebody else with a bit more money. And therefore, in regard to the rights that are enshrined in the law, I think that these are very, very progressive, even though the implementation is a bit challenging. In fact, for some of the domestic workers, you ask them, can I pay for you NSSF and NHIF? They tell you, give me that money. Don't pay it. When will I ever get it? When I'm dead? No, that's a waste of money. And so we need to create awareness on the part of the domestic worker, create awareness on the part of the employer, but more importantly, we need to have that mind of empowering the other person, because that's the only way we can really improve our status as women employers and those of domestic workers. Thank you.
So, you're going to say that?
Yeah. Jenny is just telling me that we need to keep time, so just serve your tea, then come back.
Yeah, and then we'll hear from Albert, from Medea, and from Faith, and then we can move into discussion. Yeah. So could we just get a cup of tea?
So just have your cup of tea and then
5-minute break. Comfort break. Comfort break.
And when you come back, one thing, when you come back, please sit in your general groups, because as soon as the presentations are finished, we'll break out again into group discussion.
That's a good idea.
So when you come back with your tea, sit where you were sitting when you were in your groups. Great, thank you. Thank you. Thank you. Thank you.